The first speaker this morning, again, on the law, the first speaker this morning on the law happens to be my partner, Anthony Gair. Tony is truly considered one of the experts in the law of construction accidents. And not only is he an expert because it is so much a part of his practice, but he's an expert in this area because so many people rely upon him, lawyers throughout the state of New York that have labor law cases. You can walk into Tony's office at any time of day, and he can be talking to a lawyer from any part of our state who's got a labor law case and is trying to figure out what the current state of the law is and how it affects that particular case. So it's truly a privilege to have Tony here today to speak to you about the evolving law of recalcitrant worker and sole proximate cause, and to give you an update of the current state of the ever-evolving labor law section 240. Tony?
Thank you, Howard. Can we do that over again? Good morning. I think my main job is to wake everybody up. As Howard said, my topic is the evolving law of recalcitrant worker and sole proximate cause, the current state of the labor law. Now, before I get started, just let me ask you this. How many of you out here regularly practice in the area of labor law, construction accident law? Okay, quite a few. How many primarily for plaintiffs? How many primarily for defendants, for carriers? Okay, so we have a good bunch of carriers, which could lead me to a story, but Howard told me I can't tell any of my stories, right? So, okay, no stories. One thing I think that we can all agree on is that the law under Section 240, not only as to sole proximate cause defense, the sole proximate cause defense, and the recalcitrant worker, is constantly evolving. What may be the law today could very well not be the law next year if I have the pleasure to speak with you again at that time. I was going over, when I was getting ready for this talk, some old course books from the Bar Association symposiums I took part in. This was back in 1991. Personal injury litigation under the Safe Place to Work statutes, moving from the 80s into the 90s. I keep this with my edition of the Field Code. Okay. And I had another one from 1993, personal injury litigation, workplace-related injuries, the dialogue of the 90s. This, and I'll explain to you why, some of the cases in here are still relevant, and I think will become more relevant in the next several years. We could really call this course the dialogue of the millennium, or at least the first 8 years of the millennium. In order to understand labor law section 240 and the sole proximate cause and recalcitrant worker defenses, you have to understand, and I think most of you who practice in this area do understand, that the labor law is like a pendulum. It swings from favoring one side to the other. And I think also that more than any other area of the law, the cases are very fact-specific. So that while you have general rules, those of you who read these cases on a regular basis, you say, wait a minute, I just had a case like that, different decision. So they're very fact-specific. There's also no doubt that from the late 1970s through the 80s into the early to mid-90s, the decisions and the law under the labor law absolutely favored plaintiff. the pendulum was like that. Scaffold breaks, ladder falls, you go in on a deposition, you're the general contractor, you're the owner, scaffold fell, ladder slipped, see ya, summary judgment. And I want to give you a little history because it becomes relevant, because there's certain cases that, although the pendulum has now swung more in the favor of defendants, which I have no problem with. Quite frankly, I think it had been too far in favor of the plaintiffs at one point. But in 1978, as all of you know, the Court of Appeals decided Hames versus New York Telephone Company. It's at page 85 of the course book, and Brian Shute, who has his, if those of you who've taken his decisions course, has an excellent article, and he discusses Hames in detail at page 17. Don't read it right now. In Hames, the plaintiff's decedent was killed when a ladder upon which he was standing fell. It was the conceded that the decedent owned the ladder, set it up himself, had no help in setting it up, and failed to properly place it. It was also undisputed there was nothing wrong with the ladder. Despite this, the Court of Appeals, in an opinion written by Jack Fuchsberg, who some of you may remember in his day was one of the most prominent plaintiff's personal injury lawyers before he ascended to the Court of Appeals, in an opinion by Jack, the court ruled that despite all of this, the defendant owner was absolutely liable. And for years after, we're into the 90s, that was the law. Ladder falls, scaffold falls, basically plaintiff wins. And a case that clearly illustrates what the law was and how the law has changed is a case by the name of Long versus Murnane Associates, which was a third department case, appeal dismissed by the Court of Appeals, 1979. It's at page 87. Listen to this. The plaintiff was granted summary judgment in a case in which plaintiff was injured in a scaffold collapse where plaintiff improperly erected the scaffold and was ordered by his employer to correct the dangerous condition prior to the accident, which he never did. Summary judgment for the plaintiff granted. Now, I'm going to be discussing Blake versus Neighborhood Housing Services in a minute, but those of you who know Blake know that if this case was decided today, summary judgment for the defendant. No question about it, because it's a misuse of the scaffold.